Good afternoon, everyone. The South African Bar Association on a weekly basis hosts a respected speaker to deal with a legal topic. This is one of the initiatives aimed at making an essential contribution to developing the skill set of all and any persons who represent the South African public in our courts. It is my honor to host today's speaker, who is an expert on criminal law. Our speaker today, whom all of us are familiar with, is Advocate Nerisha Naidoo. Advocate Naidoo shall be addressing us on the topic of bail. We have Laura Mbalati, who is a close friend and colleague of Advocate Naidoo, to conduct the introduction and conclusion rather. In terms of housekeeping, these sessions are recorded and appeal to participants to ensure that your microphones are muted and that your video cameras are switched off. In that regard, during the address, all participants shall automatically be muted. Should a participant have a question, simply raise your hand using the Microsoft Teams platform. During the question and answer session, a humble request is made to restrict questions to the speaker relative to the topic under discussion and only pose such question when called upon. Without any further ado, I now hand it over to Laura to conduct the welcoming of Advocate Naidoo. Over to you, Laura.
Thanks, Ahmed. Advocate Nerisha Naidoo is currently a practicing advocate with the Johannesburg Society of Advocates. She prosecuted as a state advocate as well as a senior state advocate in the Magistrate Court, High Court, and Supreme Court of Appeal. That's during her 18-year tenure at the National Prosecuting Authority. Prior to that, she commenced her legal career as a practicing attorney in general practice. Advocate Naidoo was instrumental in union activities of the Public Service Association, where she also served as the regional chairperson for several years. As a catalyst for transformation, she served on several transformation committees, including the Equity and Disciplinary Committee at the National Prosecuting Authority. Advocate Naidoo also prosecuted disciplinary hearings for the state. Being a life coach and a mentor, she has helped and continues to help people like myself and others navigate a course towards a hopeful destination within the legal fraternity. In short order, I present to you Advocate Nerisha Naidoo, our guest speaker for today. Over to you, Advocate Naidoo.
Thank you, Laura. Thank you, Advocate Bart Ford, Advocate Ahmed Jassat and team for inviting me to this platform. And I will be speaking to you on the issue of bail today. Every arrested person is presumed innocent until proven guilty. We know that. But since an arrest impacts on the liberty of a person who is presumed innocent, bail proceedings become inherently urgent. Now, when dealing with bail proceedings, the Constitution becomes important, and we know that Section 35 deals with arrested, detained, and accused persons. Now, Section 35(1)(d), it requires an accused or an arrested person to be brought to court as soon as reasonably possible. And it says not later than 48 hours after the arrest or at the end of that court day after the expiry of the 48 hours. So if the 48 hours expires outside of court hours, then on a day which is, or not a court day, then the following court day by the end of that court day. Section 35(1)(f) states that an accused or detained person must be released from detention if the interests of justice permit, subject to reasonable conditions. So here we get our standard. The standard is that the interests of justice must permit the accused release. Now, if one looks at the constitutional case of Dladla, Joubert, and Skittercut, this case emphasized that the section itself limits the rights of the accused. there is no untrammeled right for an accused to be set free. Now, the effect of bail is that an arrested person is released from custody upon payment of a determined guarantee or an amount of money. And this is to ensure his attendance in court until the matter is finalized. Now, we know a matter can be finalized in many ways. The charges could be withdrawn against an accused. The matter could be heard, go to trial. The accused can be convicted. The accused can be acquitted. The accused could be discharged in terms of Section 174 of the Criminal Procedure Act. So the matter can be finalized in many ways. Now, Section 50 of the Criminal Procedure Act also sets a limit of 48 hours within which an arrested person must be brought before a court of law for a bail hearing. So this is, it basically echoes the same as Section 35(1)(d) of the Constitution. Now, I know there's a lot of people on the platform that are very experienced, and then those that are not so experienced. So I'm going to try to cater for those that are not so experienced, because the experienced people would have had the opportunity to have conducted bail applications. So Section 50 also deals with postponement of bail proceedings, and it is important to familiarize yourself with this possibility so you won't be caught off guard if a prosecutor stands up and applies for a postponement. You should also know whether you're going to oppose the postponement or not. We don't want to just stand up and shout that we're opposing things just for the sake of. Familiarize yourself with Section 50 subsection D. It will tell you when an accused, the bail application of an accused can be postponed. But this as well says the section itself entitles the state to a postponement not exceeding 7 days. And this will tell you how important bail applications are due to the curtailment of the liberty of an accused. So if the court is of the opinion that insufficient information or evidence is at its disposal to reach a conclusion on the bail application, the matter can be postponed. If the prosecutor informs the court that the matter is going to be referred to the DPP for an issuing of confirmation, whether in terms of Section 6011A, whether the bail application is, or the trial itself is going to be Schedule 6 or Schedule 7, then the matter can be postponed, because this will impact on the bail application at the end of the day. With regard to the schedules, for the more inexperienced people, the schedules I refer to are contained at the end of the Criminal Procedure Act. So you'll get your Schedule 1 to Schedule 7, and this is what is referred to in Section 60 when you deal with bail. So we'll come back to the schedules again. So it's also important for the state to have reasonable opportunity to get certain material evidence that might be lost or destroyed if the accused is granted bail. So generally, if it is in the interest of justice that there is a postponement to be granted, then such postponement will be granted. Also, for the younger people or the advocates with lesser experience, my advice to you is the following. In respect of criminal work, it's important to build a good reputation. It's important to be respectful, not only to your colleagues, not only to the court, but to everybody that you deal with, including the police. You need to have good relationships with the police. If you start doing criminal law and you want to do criminal law, you have a passion for it, you're going to deal with the police at different stations on many occasions, and you're really going to need their help. You need to be well prepared and have a good argument. This is the best you can do for your client. You can't look for exceptional circumstances or any other circumstances that's going to support your client to get bail. You're going to have to elicit this from your client. Now, we need to be honest, we need to be careful, and we need to be smart, because our professional integrity is at risk if we do anything otherwise. Having said that, you should build good relationships with the police. You also need to bear in mind that police officials are in a very powerful position. And I'm not saying that you should be intimidated, but we don't want them to frustrate you because you just annoy them. And that is often what does happen. You will also receive much more assistance from the police. If they know you're smart enough to represent your client the way your client should be, and that you don't unnecessarily throw tantrums, and you play the person, you play the ball instead of the person. Now, in criminal matters, the investigating officer plays a pivotal role, not only during the investigations, but during the trial itself. You might want to be present during very important stages of the investigations. For example, if your client is taken out for a pointing out or an identification parade, you might want to be present, which is the right of your client. You also you want to have an amicable relationship, so you are contacted in time. It's done at your convenience, and that the best interest of your client is served at the end of the day. So the way we conduct ourselves during our matters, it actually impacts on how the criminal justice system as a whole operates. We want the criminal justice system to be efficient. We want to make good use of court time. So it is incumbent on each and every one of us to give effect to this and to do whatever, or to play our part in ensuring that this system functions efficiently and effectively. Now, it is important to have the contact number of the investigating officer and the CAS number of the docket, so you can get information easily and contact the investigating officer if needs be. But this is more so for your attorney, because that's your first point of contact. Now, Section 59 of the Criminal Procedure Act deals with police bail. Police may grant bail to an arrested person even before their first appearance in court. This can only be done by police officials holding certain ranks, and it must be done in consultation with the investigating officer. So although the decision will be taken by a higher ranking official, it's done in consultation with the investigating officer. And here again, we see the important role of the investigating officer. Now, police bail is only granted in respect of minor offenses. If you're looking at theft less than 2,500 Rand, your assault common, possession of dagga less than 115 grams. So it's quite minor offenses that the police are allowed to grant bail. Now, once bail is determined, it will be paid at the police station. You must receive a receipt. The person paying the bail will be able to retrieve the money once the case is finalized or bail is due, the bail money is due back to the person that paid. And you'll also get the next court date. Now, the bail that the police grants is only in force until the accused appears in court. And when the accused appears in court, then the court can impose conditions. If bail is refused by the police, and here again, I come back to the importance of a good amicable relationship with the police. You don't want them to get to frustrate your client getting bail or frustrate you or frustrate the procedure, which they can very easily do because, like I said, they're in a very powerful position. So if bail is refused for some reason or the other, or some reasonable reason, you approach the court. You approach the court for bail. So the next aspect of bail is prosecutorial bail. Now, Section 59A of the Criminal Procedure Act deals with prosecutorial bail, and this is where the Director of Public Prosecutions, the DPP, or an authorized prosecutor in consultation with the investigating officer. Here is the head of the investigating officer. When the DPP or prosecutor in consultation with the investigating officer authorizes the accused's release on bail on certain conditions. Now, this can only be authorized in terms of Schedule 7 offenses. So again, back to the end of the Criminal Procedure Act, you look at your schedules, look at Schedule 7 and see if prosecutorial bail applies. Now, this bail that the prosecutor grants is only valid until the accused appears in court. When the accused appears in court, the magistrate can do one of three things. He can extend the bail on the same conditions, he can amend the bail conditions, or he can revisit the issue of bail de novo. So those are the options available to a magistrate with regard to bail. So prosecutorial bail is just effective from the time the prosecutor grants the bail until the accused appears in court. Now, bail applications are dealt with in terms of Section 60 of the Criminal Procedure Act. The general test is that an accused must be released on bail if the interest of justice permit. The burden of proof is on the prosecution. Now, not generally, in criminal matters, during trial matters, the burden is on the state to prove a case beyond reasonable doubt. That is the test, beyond reasonable doubt. But in a bail application, the burden of proof is on the prosecution to prove on a balance of probabilities. Here your test changes, that it is in the interest of justice that the accused be detained longer. So please just follow me here because you're going to see a shift in the onus as we go along. So the general test, balance of probabilities, prosecutor has to prove that it's in the interest of justice that the accused be detained further, longer. You can also expect greater intervention from the magistrates during bail proceedings. They can question you as an advocate, the prosecutor. They can request further evidence. They become more involved in the bail proceedings. It's much more relaxed than trial procedure. Even hearsay evidence is allowed. Evidence of pending cases and previous convictions, it's necessary in terms of the Criminal Procedure Act, which is not allowed during a trial because this will prejudice the accused and prejudice the outcome of the trial. Now, for those of you who don't know what hearsay evidence is defined in Section 4 of the Law of Evidence Amendment Act 45 of 1988. And it's defined as evidence, whether oral or in writing, the probative value of which depends on the credibility of any person other than the person giving such evidence. I know it sounds like a mouthful, but more experienced people will realize when you break it down, it's easier to understand what hearsay evidence is. It's either oral or in writing, and the credibility of and the probative, the value of the evidence depends on the credibility of some other person besides the witness. It's the person that the witness is testifying about. So it's more hearsay evidence is another topic on its own, but it's allowed during bail applications. Now, when dealing with bail applications in court, one has to know whether the bail application is opposed or unopposed. That's your starting point. If a bail application is unopposed, you may address the court without putting the accused in the box, in the witness box, or basically calling him to testify. However, what you have to note is that even if a prosecutor does not oppose bail, the magistrate can still refuse bail or set bail on conditions if she or he, the magistrate, agrees to bail. There's nothing wrong with inquiring whether a magistrate requires further evidence. And if further evidence is required, then you have two options. You either file an affidavit by the accused, or he can tender oral evidence, viva voce evidence. The accused will be cross-examined by the prosecutor. Now, this as well is for the more inexperienced people. The accused prosecutor, and you will have the opportunity to re-examine him or her. Now, remember that the merits of the matter are not really relevant in a bail application, but they are relevant to the extent when you have the strength of
Advocate Naidoo. Sorry, Nerisha. Sorry. Forgive me for the interruption. I need you to step like about 10 seconds back. Your internet connection went out. Just 10 seconds back. Sorry. We lost you for about 10 seconds.
Okay. So I was dealing with the merits. Am I okay? Is it okay to go back? Okay. So I was dealing with the merits, and what I said is that the merits of the matter is not important for the purposes of bail application, but it does become important when you're dealing with the strength of the state's case. One will assess the strength of the state's case when it comes to alleging whether the accused is a flight risk, or assessing whether the accused is a flight risk or not. If the state's case against the accused is overwhelming, and the accused will face a long, lengthy sentence if convicted, then the accused will be deemed to be a high flight risk. So whether you file an affidavit or lead evidence of the accused, the requirements of Section 60, subsection 4 must be satisfied. Now, Section 60, subsection 4 deals with the interest of justice, not permitting the release of the accused from detention. And it outlines circumstances when it's not. So where there's the word that is used is likelihood. So where there's a likelihood that if the accused is released on bail will endanger the safety of the public or any person, or will commit a Schedule 1 offense, again, you go back to the schedules, then it's not in the interest of justice to have to release the accused from detention, or he will attempt to evade his trial or her trial. So this is where the accused becomes a flight risk. Now, one of the things I was asked to address you on was the Bushiri matter. And the Bushiri matter, as we all know, Shepherd Bushiri and his wife Mary were facing several charges in South Africa, including fraud, money laundering, theft. There's a lot of other charges. The matter is still sub judice. The investigations are still ongoing. And they were granted bail. They were granted bail of 200,000 Rand. They were previously granted bail of 100,000 Rand each. So, the argument was they were on bail. They didn't abscond. So why will they abscond now? They were granted bail of 200,000 Rand subject to conditions. The conditions were that they will report to the police station every Monday and Friday, which is a usual bail condition, and a common bail condition, and that they will hand over the passports to the investigating officer, which they said was already done. But despite this, and till today, nobody knows how they left the country. It's suspected or speculated that they left on a private jet with lots of money, but they left. And the difficulty that the state is facing now is to get them back to face their trials. And I say trials because there are many matters pending against them where there might be separation of trials or new charges put to them. But some of the charges also includes contravention of exchange control regulations and that kind of thing. So they fled to Malawi, and what they want now is for the witnesses from South Africa to come and testify in Malawi. And that obviously can't happen because it defeats the purpose of extraditions, and South Africa and Malawi have an extradition agreement. But when you institute extradition proceedings, then it becomes a legal issue in the other country as well. And there's certain requirements that need to be complied with and fulfilled. So extraditions is also another area that's a topic for another day. But it's difficult to get them back. These are very high profile people, and I'm told that it was one of the reasons that it wasn't expected that they would flee, but they did. And now they refuse to come back. So there's a lot of money, a lot of funds that are being expended in getting these people back. This is not the only case. Because this is a high profile case, you're getting to hear about this. High profile cases are reported, but there are many cases where it cannot be in the interest of justice, where accused are just allowed to flee. And when they flee, it's not necessarily overseas. They can flee from Gauteng to Durban or Gauteng to the Free State, anywhere in KwaZulu-Natal, and it becomes difficult to trace them and get them to stand there. So that's one of something I wanted to mention. I don't know if it addresses the issues Bart wanted me to address. So when an accused testifies orally, there is more evidential weight given to his or her evidence. The accused or his legal representative is obliged, in terms of the Criminal Procedure Act, they're obliged to inform the court whether he or she has any previous convictions or pending cases, and whether the accused is out on bail on any of those matters. So what I'm going to say to you next is very important. If you remember, I said to you initially, follow me with regard to the interests of justice requiring that the accused be detained further. That was what the prosecutor had to prove in a bail application. Now, where an accused is charged with an offence relating to a Schedule 5 offence, the court shall order that the accused be detained in custody. So the court is obliged to order that the accused be detained until the accused is dealt with in accordance with the law, that is to have a bail application, and having been given reasonable opportunity, that's to present his case, and adduce evidence which satisfies the court that the interests of justice permit his or her release. So the test is similar. The interest of justice permits a release here, and initially it was warrants the detention, further detention. But here you see a shift in onus. The onus shifts to an accused when it is a Schedule 5 offense, because the accused now has to prove that it is in the interest of justice that he be released from custody. So when an accused is charged with a Schedule 6 offense, the court will order that the accused must be detained in custody until he has reasonable opportunity to adduce evidence that will satisfy the court that exceptional circumstances, this is where I said to you earlier on, don't fabricate exceptional circumstances for your client. Let it come from him or her. So the court needs to be satisfied that exceptional circumstances exist, which in the interest of justice permit his or her release. So the standard of the interest of justice is still the same, but the burden is heavier on an accused because with Schedule 5 and 6 offenses, they're much more serious than other scheduled offenses. So after all the evidence is led, the accused, represented by yourself, and the state will both have an opportunity to address the magistrate in argument. And the magistrate will give a reasoned judgment as to why bail is granted or refused. And the person responsible to oversee that the bail conditions are complied with is once again the investigating officer. So, like I've said, maintain good relationships with the investigating team, the investigating officer, the police station in general. So if bail is refused, then your remedy will lie in a bail appeal. A fresh bail application can only be brought if bail has been revoked or cancelled or new facts have been established. So that is how you deal with a bail application, your police bail, prosecutorial bail, and your bail application in court. That is the end of my presentation. And I'll hand you back to Laura.
Sorry, thank you so much, Advocate Naidoo. I thank you for that exceptionally informative address. Your address was meticulously articulated. You have addressed majority of the participants' questions. This is qualified by the fact that a number of participants has raised their hands, naturally to ask a question, and thereafter lowered their hand soon thereafter. And I reasonably assert that the only reason for them to do such is that you have answered their questions. So once again, thank you for that exceptional address. I personally commend your advocating, correctly so, to the importance to having a good relationship with the South African Police Service. I have now opened the platform for a brief question and answer session. To those that have a question, simply raise your hand using the Microsoft Teams platform, and when your name is called, simply allow your mic and or your video to pose your question directly to Advocate Naidoo. Advocate Naidoo, I shall initiate the question and answer session. My question relates to the profound impact COVID-19 has on the evolving criminal law jurisprudence, in this instance, bail applications. Courts could take judicial notice of the fact that the COVID-19 pandemic represents a material change in circumstances. I expressly use the word could because it could be argued that taking judicial notice of the impact of the COVID-19 pandemic must be based on evidence. Judicial notice dispenses with the need for proof of facts that are notorious or generally accepted so that not to be the subject of debate, or that it is capable of an immediate and accurate demonstration by resorting to readily available resources of indisputable accuracy. Now, I put it to you, Advocate Naidoo, that such would apply to a person in custody who has a medical condition that puts them at a higher risk of contracting COVID-19 whilst in custody. In that regard, what would be your comment to my submission that the COVID-19 pandemic could serve as a material change in circumstances justifying a new circumstance or fact to consider a bail decision.
Thank you for that. You must appreciate the fact that we have a lot of inmates.
Sorry, I was interrupting you to tell you your camera is, but it's on now. Thank you so much.
Okay, there's a lot of inmates in custody throughout the country, throughout the world. It is not practical to release all of the prisoners that are awaiting trial or that are arrested. Some arrests have been taking a long time to make. Like I said, it's very difficult to track and trace with accused to get them arrested and get them to stand trial. There are measures in prison that are implemented due to COVID-19. If you read the newspapers, you would realize, or the news sites these days, you would realize that the prisoners have been prioritized, and there's also staff working at the prisons. They have been prioritized in terms of vaccination drives. So they are being given priority, but it is highly improbable that the justice system will favor the bail applicant to such an extent they will have to be released due to COVID. It sounds harsh, but it's reality. You have to weigh the interests of justice at the end of the day. COVID is deadly to a lot, but not to everybody. So it's not necessarily a death sentence. They are being vaccinated, and hopefully COVID protocols are being maintained. We can only hope.
Thank you so much, Advocate Naidoo. That has answered my question correctly. So there's a question from Advocate Bartford. Advocate Bartford, you can simply unmute your mic and or your video.
Nerisha.
Hi, Bob.
I hope you can hear me. Firstly, thank you so much for the presentation. I am unfortunately unable to activate my video camera. I don't know why, but be that as it may. I have firstly an apology. Firstly, you would have seen on the LinkedIn advertisement that we flighted, I've changed your surname from Naidoo to Pillay. Please forgive me for that. I have no idea what overcame me, but please accept my apologies when you discover that you've been renamed.
They say, what's in a name, Bart?
A rose by any other name is still a rose, am I right?
Yes.
Right, so my first question is this. Is a bail, a decision on bail appealable or reviewable? And if it is, what happens in the interim when the detained person seeks to appeal the decision on bail? The second question would be, for a reconsideration of bail, when there are new facts, how would the court view on, or perhaps better said, how would the fact that new facts come to the fore be able to be used in circumstances to allow the accused or the detained person to be released from bail? Alternatively, the person who was whose bail had been refused or bail had been granted, better said, to have their bail revoked.
Okay. Bart, let me start with your last question. The criminal procedure does provide for cancellation of bail and revocation of bail. So if the police come up with, for example, if an accused has not abided by his bail conditions, then bail can be cancelled. Obviously, you forfeit your money to the state, and that's how that is dealt with. On new facts with regard to the accused, if there are new facts that are compelling for the court to consider and does weigh in his favor, where the interests of justice will demand that he be released, then it is the right of a court to hear that. and release him and come to a fresh decision. Have I answered your question?
Thank you so much, Nerisha.
Okay. Then with regard to appeal or review, bail is a final decision. It can be appealed, and the appeal will go to the High Court of that division. In the interim, the decision stands. The accused remains in custody until the decision is overturned on appeal.
Thank you.
Thank you so much, Nerisha. There's a question from Mbuhi. Mbuhi Selo. I hope I'm pronouncing his name right. Ms. Selo, you can just simply unmute your mic and roll your video.
Thank you. I just want to find out whether the and please excuse my ignorance in this case, whether the CPA is the only place where we find schedules, or whether there is another place where we can find schedules. The reason I'm asking is now recently I was looking for domestic violence where it was, and I couldn't find it in any of the listed schedules under the CPA. I only found common assault. I don't know whether common domestic violence, the offense would be under common offense, or but that's basically the question. Whether do we have something that lists all the schedules, or the CPA is the only place where we can actually find the schedules? Thank you.
Okay. Selo, the Criminal Procedure Act has the schedules. Like I said right at the back, it has schedules 1 to 5. 1 to 7. If you're looking at domestic violence, then look at the Domestic Violence Act. And that should give you an indication as to how to approach your bail application. But the interest of justice is your primary factor that determines whether an accused should be released on bail or not. And if it's not a scheduled offense, then that's basically it. That's a basic test that you have to use. So the prosecutor needs to prove that it's in the interest of justice that the accused be detained further.
Thank you.
Thank you, Advocate Naidoo. There's a question from Franz Dlamini. Franz Dlamini, you can simply unmute your mic and your video.
Thank you. My question, Advocate, relates to the provisions of Section 50, subsection 6. I just want to find out, in order to perhaps guard against the abuse of the provisions of Section 50, subsection 6 by the state, are you allowed as the defense to oppose that application? And if so, is it irregular or not in the process of opposing the application to lead the viva voce evidence? That is my question.
Okay, thanks, Franz. Franz, with regard to Section 50, subsection 6, it outlines circumstances under which the state might apply for a postponement. So the Criminal Procedure Act in itself entitles the state to apply for a postponement. And like I say, it also stipulates 7 days at a time, because bail deals with the liberty of a person, and it needs to be expedited. So if you oppose the bail application, that's why I said earlier on, you don't have to oppose everything. You don't have to be unreasonable. Look at what the Act allows the prosecutor to do, the reasons the prosecutor is putting forward for the application of the postponement. If it is not in accordance with the Act, you can aggressively oppose it. You don't necessarily have to put your client in the box to oppose it. You can argue it by getting instructions from your client. And if necessary, say to the magistrate, I would like to put my client in the box. But I can't see how that would be necessary other than an address from the bar. You know, you don't want to put your client in the box unnecessarily and subject him or her to cross-examination. It's not a very pleasant place to be.
Thank you.
Thank you so much, Nerisha. There's a question from Quentin Zulu. Quentin Zulu, you can simply unmute your mic and or your video.
Thank you. Yeah, it's Quentin Zulu from a candidate attorney at Erasmus Attorneys. I just want to find out, in an event that the police may not grant bail for part 2 or 3 of Schedule 2, where such a crime does not appear in Schedule 7, the onus is upon who to grant bail in such an application. Thank you. And thanks to Laura for the invitation.
Okay. Quentin, if the police do not grant bail for offences that they can or they're obliged to consider bail for, then you bring an application to the magistrate. So the prosecutor doesn't become involved if police bail is refused. With regard to the schedules, if it is not scheduled, then it has to go to court. If it's not in the schedules for the police to consider, then it goes to court. If it's Schedule 7, then you know you can approach a prosecutor for the granting of the bail. There's just something I think I can mention at this stage as well. After our bail applications are no longer heard, I think there's been an abuse with regard to the process. But if a bail application is extremely urgent for some reason or the other, then it can go to the High Court. But we don't want to wake up a judge to hear a matter in the High Court when it's not urgent. You've got to satisfy the court that it is really urgent that warrants a judge hearing the matter.
Thank you. Advocate Naidoo, regrettably, I have closed the question and answer session due to time restrictions. I now hand it back over to Laura to conduct the conclusion. Over to you, Laura.
We'd like to express our sincerest gratitude to Advocate Nerisha Naidoo for taking her time out to address us on the bail topic. May you continue to be the flame within others. Thank you so much, Advocate Naidoo.
It's a pleasure, Laura.
Thank you. By way of final conclusion, we sincerely thank Advocate Naidoo for her informative address and naturally for her time. We further thank Laura for her excellent welcome and conclusion. Appreciation to all those that have participated virtually and shall be watching the session at their leisure. These sessions are recorded and the recordings can be found upon the South African Bar Association website, that being www.rsabar.net. Thank you.